Good afternoon, honorable speakers of Senate and Parliament, ministers, excellencies, distinguished guests, ladies and gentlemen. A warm welcome to the mock trial as part of the commemoration of the events commemorating the 20th anniversary of the adoption of the Rome Statute. Today's program will be a mock trial, and I kindly invite the registrar to step forward and give the introduction remarks.
Welcome to the ICC Senior Mock Trial involving the trial of Captain Yossarian, a Catch-22 situation. This is a senior mock trial in the sense that the participants in it are real judges and senior legal professionals and academics, not university students. Our jury is made up of ambassadors based in The Hague. And that jury bit is one telltale sign that this is a mock trial. We have added it in purely for dramatic purposes. As you may know, there are no jury trials at the ICC, so the ambassadors based in The Hague need not worry that we're about to summon them as a practice to attend the court and pass judgment on someone's guilt or innocence. The mock trial kicks off events marking the 20th anniversary of the adoption of the Rome Statute. The formal, commemorative events take place tomorrow at the premises of the ICC. In staging this mock trial, we have aimed to expose the audience, very briefly, to certain aspects of war crimes, being a category of the crimes over which the Rome Statute confers jurisdiction to the ICC. So the objective is, strictly speaking, educational. But we aim to do so through the medium of entertainment, and we hope you enjoy it. The mock trial is loosely inspired by the characters and story of the novel Catch-22. We have borrowed liberally from Joseph Heller's World and Words, but we have done so lovingly. And we give the author and his work the fullest credit for inspiring this exercise. The mock trial is set in the fictionalized state of Pianosa. As some of you may know, Pianosa is actually a real place, a beautiful Mediterranean island that forms part of Italy. And Joseph Heller's novel is set there. But everything else about the novel is fictional, at least as we understand it. It is certainly in that spirit of pure fiction that we approach our story tonight. Now, the accused is John Yossarian. At all times of interest to us, he was a bombardier of the 256th Squadron, based on the island of Pianosa. He was a captain at that time. Now, his rank of captain is in the same sense as a captain in the land army. That is to say, he was not a senior officer at the level of, say, a colonel. The rank of captain suggests, for some air forces and navies, a more senior rank. But Captain Yossarian was a junior officer. Yossarian is accused of leading a bombing raid on an undefended village on a mountainside. He did so on the orders of his superiors. Their objective was this: by reducing this poor undefended village to rubble, the rubble would then become a roadblock, which would require clearing by the enemy, thereby impeding the advance of the enemy in their direction of movements towards the military forces to which Captain Yossarian and his commanders belonged. It is a result of that bombing mission that Captain Yossarian is accused of individual criminal responsibility in the sense contemplated by the Rome Statute as follows: directing an attack against the civilian population, inflicting excessive collateral damage, and bombing an undefended village. He is or may be charged with additional crimes, but we'll get to that in a moment. The crimes underlying the mock trial are quite sad, as they almost always are in real life, so much so that we won't actually be discussing them in their detail today. For the purposes of our exercise, the parties have reached factual agreements that this bombardment happened and that no evidence need be presented as to the attack itself. The only contested issue left for the trial is whether there are grounds to exclude individual criminal responsibility on the part of Captain Yossarian on any of the known ground defences that the Rome Statute recognises. Some of those grounds are whether Captain Yossarian acted under duress, acted under valid superior orders, was suffering from disease or impairment of the mind at the relevant time, or indeed whether reducing the undefended village to rubble could be said to amount to military necessity. And now, ladies and gentlemen, distinguished guests, Your Excellencies, please enjoy the mock trial.
All rise.
Thank you very much, and welcome everyone. First of all, we want to thank the judges of the Supreme Court of the Netherlands for allowing us to use their premises for this occasion. Court officer, could you call the case?
The case of the prosecutor versus John Yossarian, a catch-22 situation. The bench is composed of Judge Ebo Osuji, presiding, Judge Trendafilova, and Judge Morrison. We're in open session.
Thank you very much. Now we will take the appearances from counsel, but before we do that, I want to explain that we have the 5 seconds rule. So this is something all counsel who appear before the ICC know. The idea is for there to be pauses of 5 seconds so that interpreters can interpret better. But on this occasion, I think we can do with 3 seconds or less. Appearances, please. Beginning with prosecution.
Thank you, Your Honour. For the prosecution, Christine Chinkin and my colleague, Christopher Godso.
Thank you. And the victims' counsel, please.
Good evening, Mr. President, Your Honours. My name is Arçlın Naren Titek. Today, I'm appearing as the legal representative of victims. Thank you.
And the defense.
Thank you, Your Honor, Mr. President. William Shabas and Helen Brady for the defense, and our client, Captain Yossarian, is also present.
Thank you very much, Professor Shabas. Now, we will turn to the evidence presentation in this mock trial. As you may have heard from our omniscient narrator, the scope of this trial is very limited. In fact, so limited that we shall try and finish it in 1 hour or at the most 2. As some of you know who are familiar with the ICC proceedings. We do not do our trials in 1 or 2 hours, or even 2 years. So if we managed to do it in 2 years, we would have been, we would have done well. The Chamber understands that each party will call only one witness in the case, but before turning to that, the evidence in the case, we understand that the prosecution seeks to bring a procedural motion before the Chamber to amend the indictment. Let us turn to that.
Thank you, Your Honour. Yes, we would like to add one more charge relating to war crimes, and that is the charge of endangerment to the authority of a commanding officer.
Mr. President, I have a question.
Yes, please.
I have a question to address to the prosecution. The offense over which the Rome Statute has conferred jurisdiction to the ICC are quite clearly known. And recently, when I checked again the Rome Statute, these are the crime of genocide, crimes against humanity, war crimes, and as of tomorrow, the crime of aggression. So what you're referring to, the endangerment to the authority of a commanding officer, does not appear in the Rome Statute. Also, the list of war crimes runs quite long, but still, if we are to check again this list of war crimes and also in the element of crime, such a crime of endangerment to the authority of commanding officer appears nowhere. How would you explain this, prosecutor?
Thank you, Your Honour. To start with, we have obtained additional evidence that in addition to the charges confirmed, Mr. Yossarian was engaged in a personal dispute of a nature likely to undermine the authority of his commanding officer, so that while he was stationed in Pianosa, Mr. Yossarian entered into this personal dispute with his commanding officer. And we say that this dispute was of such a nature as it had the potential to rupture the dignity and standing of his commanding officer and reduce him to a laughingstock among his troops. That would undermine the commanding officer's ability to exercise effective control over them. And under international criminal law, the commander's effective control is a matter of absolute critical concern, because it is that ability that enables commanders to prevent and repress the tendency of troops to commit war crimes themselves. So that being the case, the prosecution argues that the jurisprudence of this court ought to be developed in a way that deters the undermining of the authority of the commander.
Sounds to me like you're making an international crime of anyone who ruptures the pomposity of his superior. That sounds very creative.
But what are the facts of this conduct you're talking about, this dispute?
May it please the court?
Yes, Professor.
Perhaps
Schubert.
at this point you would allow me the floor to make a few comments on this unusual and creative motion by the prosecutor.
Please proceed.
Your Honors, the motion to amend the indictment should be rejected to the extent that the crime to be added is endangerment to the authority of the commanding officer. The specific facts are quite irrelevant, as Your Honor has rightly pointed out, and as my learned friend does not appear to dispute. There is no such crime listed in the long catalogue of crimes over which the Rome Statute confers jurisdiction on the International Criminal Court. And for that reason, the charge that the prosecution seeks very creatively to add to this proposed amendment is legally admissible on account of Article 22, Paragraph 2 of the Rome Statute, which preserves the principle of legality and forbids extending crimes within the Rome Statute by creative analogies. In any event, the amendment is also factually irrelevant to these proceedings for another reason. And that's because the orientation of the charges of war crimes, as confirmed so far, is that the accused committed the crime as charged because he was carrying out the specific orders of the same commanding officer who ordered him to commit the war crimes. That is to say, it was his commander that specifically ordered him to bomb the undefended village. The charge is not that the subordinates had committed the war crimes and that the commander had failed to prevent or repress it because his authority was undermined by my client.
Okay, I think I'll confer with colleagues. And
Yes.
all right, thank you very much, Counsel. The bench is persuaded by the arguments of defense counsel. The motion is overruled. There will be no amendments to the indictment. Thank you. Now, we will proceed to the evidence. Let's bring in the first witness. The witness for the prosecution. Good evening, witness. Now, normally we will take you through a long routine of explaining what we do in court and also swearing you in. But on this occasion, I'll just rest content with telling you not to lie in your evidence. Prosecution.
Thank you, Your Honour.
Thank you.
Good evening, Mr. Witness. Your name is Dr. Danica,
Yes,
and during the war, you were the squadron physician to the 256th Squadron, Captain Yossarian Squadron.
yep,
Good. So in your capacity as squadron physician, Dr. Danica, you enjoyed certain powers, and that included the power to ground pilots and bombardiers so that they wouldn't be able to fly in combat missions again. And even you had the power to permanently discharge them from the Air Force on medical grounds. Is that correct?
indeed so. There's a rule saying that I have to ground anyone who suffers from insanity.
Thank you. So did Mr. Yossarian ever try and get grounded or discharged for this reason?
Oh yeah, lots of times. In fact, it was an obsession for him, but he was locked in Catch-22.
Locked in Catch-22? Please, could you explain that further, Dr. Danica?
You see, I could not ground him or recommend his discharge on grounds of insanity as he presented it. He complained that he was sick of having people try to shoot him down and kill him every time he would go out on a bombing raid. So, as he saw it, anyone who would go up on a bombing raid in the face of such mortal danger must be someone possessed of an insane mind. So he wanted to be discharged from the Air Force on that ground of insanity.
Okay, and?
But I told him that the logic of Catch-22 worked rather in the opposite direction. That being to the effect that a concern of one's own safety in the face of mortal danger, that our real and immediate is the process of a very rational mind, not the opposite.
So what does that say about Captain Yossarian's state of mind?
That is to say, a truly crazy person wouldn't really have perceived that real danger or mortal harm and asked to be rescued from the prospect. You'd have to be crazy in the colloquial sense of the idea to keep flying combat missions in the middle of a war. But you are not insane in the psychiatric sense of an affective disorder for not caring to be killed for doing so.
So your conclusion then, Dr. Danica, was that he was not crazy in the medical sense, and so that Captain Yossarian could not be discharged on that ground.
Right. I couldn't conclude he was medically insane. It was not enough for him to be sure in his own mind that he was crazy.
And even in the colloquial sense of someone being crazy to engage in a bombing raid where there was a chance of him being killed. Would you say in that instance that Captain Yossarian would qualify, given that all he did was to try to avoid going up on these bombing raids?
Your Honor, I object. This is the prosecution's own witness, and she's suggesting the answer in the question. She's not allowed to cross-examine her own witness.
Objection overruled. The question was merely trying to point the witness to the essential point of the question. Please proceed.
Well, the colloquial sense of crazy implies a clear element of the bravado, if you like. Captain Yossarian had not a single fiber of bravado in himself. To the contrary, he was your classic wimp. He was petrified to have to go out on the bombing raids. He wanted absolutely nothing to do with it.
So he really was caught in quite some catch-22, witness.
Yes, indeed. He was under military orders to go up on the bombing raids. He had no choice. His refusal would have resulted in court-martial.
Your Honor, that's precisely our point. Your Honors, I move to stop this entire trial right now and to declare the accused acquitted.
And what does the prosecution counsel say to that?
The prosecution counsel thinks that it is very clear that Dr. Danica is giving evidence of the state of mind of Captain Yossarian, and that that is absolutely core to the defences under the Rome Statute before us, and that accordingly the trial must progress.
Thank you very much. I think counsel for the defense at this stage, it may be we should listen some more to what the evidence unfolds, and all counsel in the case would have full opportunity to address the court and make whatever submissions they want in the end. So we'll proceed.
Thank you.
Good afternoon, Dr. Danica. Do you ever remember Mr. Yossarian being hospitalized?
Oh, yeah, lots of times. He seemed always to be on admission to the hospital for one reason or another.
Were any of those episodes of admission memorable for any reason?
One time I remember he claimed he was seeing everything twice.
What do you mean by seeing everything twice?
Well, in the ward they brought in a guy who began to see everything twice. Without warning, he just sit up in his bed and start shouting, "I see everything twice." When Yossarian saw the commotion and all the attention that this guy generated, he too started claiming that he was seeing everything twice. The doctors put them next to each other in the same ward.
That sounds like a serious affliction.
Yes, it was for that guy, but I could not say the same thing for Yossarian.
Is it possible that true shell shock in war could result in the victim soldier seeing everything twice?
I have no reason to doubt that it was so for the other guy. Indeed, I am prepared to accept that serious concussion to the brain can result in double vision or seeing the same thing twice. But that was not the case with Yossarian.
Why would you describe the other guy's condition as real, but you wouldn't say the same thing for Yossarian?
The first guy died the next day.
The first guy died the next day. And how did that affect Captain Yossarian, who was occupying the next bed?
Yossarian promptly went back to telling everyone he was seeing everything once.
So the other guy's death proved to be something of a cure for Yossarian's own condition.
That is certainly one way, the unorthodox way of looking at it.
The unorthodox way of looking at it. What is the orthodox way of looking at it? Are you suggesting that Yossarian was faking when he said he saw everything twice?
That would be one explanation.
Is there any other?
You could say that we had cured him of a very serious medical condition. We have a very good medical team, you know, headed by me.
I see. But Yossarian was not always a malingering coward. He once received a medal for bravery, didn't he?
He did receive a medal for bravery, yes.
And please tell the court about that.
He bombed a bridge of key strategic importance to the war. The problem was he didn't release his bombs on the first pass, so he had to go back a second time, and our squadron suffered a lot of losses in that second pass.
Now, help me understand this. If he bungled the bombing mission, and that resulted in much loss to his squadron, why did he still end up getting a medal?
Well, it was for the report. If the higher-ups had written that Captain Yossarian didn't release his bombs on time and then got our men killed on a second pass, that would have looked terrible. But if he was courageous enough to do a second pass to finish the job, then it would look good. So they gave him a medal.
Thank you, Dr. Danica. Thank you very much, Mr. President. That will be all for this witness.
Thank you very much, Counsel.
Dr. Danica, you said he missed his target the first time and he had to go back a second time. Did he hit the target on the second time?
No.
And they still gave him a medal for bravery?
Yes.
Right.
A witness, but isn't there a higher principle that might have explained the award of that medal to him?
I'm not sure I follow you, Mr. President.
Well, there is this theory of manful incompetence. Have you heard of it?
Manful incompetence, Your Honor?
Yes, manful incompetence. Now, we can call it a concept. We need not call it a theory. You still haven't heard of it, manful incompetence, no?
No, Your Honor.
Now, it has to do with the idea that history is full of mind-boggling bungling executed with insouciant hubris associated with men. You've not heard of that? And that men ought to be rewarded for doing so. Let me tell you about it. There's a gentleman, he's now dead. His name was Stephen Powell, associated with this concept. And it gives some, perhaps, true meaning to the idea of the word history not being history. It's about men. The author authored at least 3 books on the subject, and the guiding principle is summed up as follows, quote, "Success is overrated. Man's real genius lies in quite the opposite direction." Have you heard it? Mm-hmm. Perhaps that may explain why he was given the medal by his commanders. Maybe there were some sort of secret adherence to that principle.
That may very well be.
But, President, that must be about man's real genius. Do you mean man's male or genius in the neutral form?
Well, I was merely quoting. The concept was stated in those terms, not in gender-neutral terms. Ordinarily, I would correct things and editorialize and put it in gender-neutral terms, but in this case, I just didn't care. I didn't think that women would care to share in the concept that celebrated the, shall we say, bollocksery of men, knowing about the constant stream of bunglings that men have done that have inflicted so much misery to humanity. Let's think about, the slavery, World War I, World War II, and countless wars in between, before and after that. And also the production of weapons of mass destruction and their actual use. many genocides and begin to wonder how we haven't gone extinct. So that's what I'm referring to. And you see men constantly associated with this. And when you think about those wars, perhaps Professor Chambers can come in. Have you seen the movie Wonder Woman?
I didn't see the movie, but I read the book.
Well, that is one instance where there was a war that women were predominantly associated with. My daughter made me watch that movie, and I'm glad she did. Best decision I made this year. It has to do with a bunch of soldiers invaded a colony of women in the Amazon jungle. Invaders thinking, as men usually do when they get up to these things, that there was an easy walk in the park. In the end, some of the invaders were only lucky to escape with their tails between their legs. I hope I haven't given away the plot of the movie.
But I'm not sure that human race is yet out of the danger of the kind of bunglings that you're speaking of. My point was, out of the context of what you are telling us right now, that when we speak about genius, it shouldn't be stated only in male terms.
And I quite agree with that. Still, there are certain kinds of ineptitude that seem to be the preserve of men.
Like what?
Well, there are so many of them. I remember one story. This happened in 1977. A chap was trying to fly from the West Coast, I think, San Francisco, to Italy. Happens that the plane made a 2-hour fuel stop in New York at JFK. So this gentleman went to town and spent 2 days in Manhattan thinking he was in Rome. I don't know of any women who would make that kind of mistake.
But do you know any man of that kind?
I decline to answer that question. Let us say that I completely depend on my wife whenever we go somewhere I don't know. I don't want to get lost. Now, there's another story that also brings out this theory of manful incompetence. Now, we're in July, are we not, witness? This happened in July 1980 in Vancouver. Now, I do not remember now whether this is Vancouver, Canada, or Vancouver in the US. Witness, have you heard of Rumpun? R-O-M-P-U-N. You know what that is?
No, Your Honor.
Okay. It is a horse tranquilizer. In July 1980, this animal control officer was called in to sedate an overexuberant donkey. Now, we don't need to spell out in what way the donkey was overexuberant. The more important thing was that he showed up and filled a large syringe with Rumpun. Wanted to sedate the donkey. The donkey wanted absolutely nothing to do with it. In the usual manner of man, he had to have his way. Donkeys are very stubborn, we know. Donkey said, no, in your dream, pal, he was thinking. Now, in the ensuing struggle between man and donkey, the syringe slipped. Instinctively, the man reached out to catch it. And the syringe went right into his ring finger. Let's say the struggle was over in a matter of seconds. And the donkey carried on his merry ways. A man had a deep and peaceful slumber. That's another story of man's, what do we call it? Manful incompetence. So witness, those are some examples I give you on the subject. Maybe that explains when somebody bombs his target and loses and misses, he still gets a medal for it. Now.
Yes, well, I entirely agree with Judge Trendafilova on the matter, but the witness's testimony about the accuracy of bombing raids reminds me of one story that my father told me out of the Second World War. By the way, does anyone know where Borkum is?
Borkum? I think that's in the North Sea, isn't it?
It is. It's one of the islands that belongs to Germany off the North Sea coast. Well, in February of 1940, a Royal Air Force bomber pilot sighted 2 warships, destroyers round Borkum, and he promptly zeroed in with remarkable efficiency. He strafed and bombed them and inflicted absolute mayhem on both of the warships. Rarely indeed in the annals of aerial attack had one plane done so much damage to 2 ships at the same time. Unfortunately, as it turned out, both ships belonged to his own country's Royal Navy.
There you go. Thank you. I think that makes the point. So we do get the point. Yes, we do speak in gender-neutral terms. The point is just to illustrate, Judge, that there are instances where some kind of bunglings may be reserved some.
And of course, we have to be very careful when we use the word genius. That was my point. Sometimes, depending on the context, it should be non-gender neutral, but I would prefer sometimes, and there is a saying, when we are going to refer to female, in female terms, there is a saying that when you want a job to be perfectly well done, just assign it to a woman. So I wouldn't object that it is used in female terms.
Point taken, and quite I agree with you. Now we move on. Where are we with counsel? I think we finished the witness for the prosecution or the
Your Honor,
prosecution.
I think we need to hear from the representative of the victims.
Yes,
and of
indeed.
course, I have my right to cross-examination.
You will be cross-examining. First, we will hear from the victims' counsel. Victims' counsel, please.
Thank you, Mr. President. Now, Mr. Denica, we represent lots of victims of the village that was completely destroyed during Mr. Yossarian's bombing raid. And needless to say, victims have experienced great suffering to the commission of the crimes charged. And we understand that you haven't visited this village yourself. But, sir, are you able to tell this court about some of the suffering you did see during the war?
Yes, I did see great suffering during the war, indeed. Look, my medical practice was finally starting to take off back home before I was drafted and sent off to this bloody war. All the doctors back home, those who had avoided the draft for one reason or another, were making real money, but I had to take government pay to get shot at all the time. Do you know how much I could have made had this war never happened?
Mr. Witness, sir, I didn't ask you about your own suffering. So I asked you about the suffering of the innocent victims of the war. In fact, are you in a position to talk about anyone else's suffering other than yourself?
But I know my own suffering best.
How true. But your answer is very unhelpful. No further questions, Your Honor.
Thank you very much, counsel. We will now, counsel, finally come to your cross-examination. Defense counsel.
Thank you very much, Your Honor. May it please the court. Doc, I can call you Doc, can I not?
Yes, please.
Doc Denica.
By all means.
Isn't it true that Captain Yossarian asked you many times to ground him?
Yes, he wouldn't stop bothering me about it.
So why didn't you?
Because of the rules. I couldn't. And quite frankly, I didn't see what was so special about his problem. Look at me. My precious medical skills were being wasted in this war while the other doctors were making so much money back home. It would have been much easier to have refused to have helped him at home or under nicer circumstances. Refusing to help him during the war was just so frustrating.
Yeah, but, sir, Mr. Yossarian was just trying to save his life.
I'm not in the business of saving lives.
But you're a doctor.
Correct?
Oh, well, just move on. Now, once in the hospital, you spoke with Dr. Sanderson, and Dr. Sanderson said that Mr. Yossarian was insane. Isn't that true?
Yeah, Yossarian reported to me that Sanderson had said that.
Do you know why Sanderson would describe Yossarian as crazy? In other words, what was the basis for Doc Sanderson's diagnosis?
It was not a diagnosis. As I understand it, it was because Yossarian described Dr. Sanderson as crazy.
So, is it your testimony that Dr. Sanderson called Yossarian crazy as a kind of payback because Yossarian had called Dr. Sanderson crazy?
That's right.
And so, after this meeting, did Yossarian tell you about Dr. Sanderson's diagnosis?
Yeah, he did.
And what did you say when Yossarian told you that?
I just asked him, so what? He kept insisting being crazy was going to get him sent home. But if the crazy man won't go there to get killed in combat, then who else will go?
If the crazy men won't go out there to get killed, then who else will go? Interesting. Well, Dr. Nika, I'm going to move on to another subject. Is it true that you're dead?
I beg your pardon?
Isn't it true that you're dead?
I heard you the first time.
I thought you wanted the question repeated.
No, I didn't.
You said, I beg your pardon.
Because I could not believe I was being asked such a clearly nonsensical question. I'm right here. I'm talking to you. I'm clearly not dead.
But haven't you seen the report confirming that an airplane piloted by Captain McWatt crashed into a mountain, and the report necessarily implies that you are dead?
Yes, yes, that is what the document claims, but no, I'm not dead.
Well, but I have the report. It says that Captain McWatt was flying with 2 new pilots and yourself. The 2 new pilots parachuted out of the plane to safety, and no one else did. Then the plane crashed with no survivors. So, have you got an explanation?
An explanation on the fact that I'm not dead? I can't honestly believe we are having this conversation.
Well, don't you know that the War Department sent a letter to your wife confirming that you were killed in action?
Yes, I did, and thanks for that, by the way.
I'm not the War Department.
I had to send her a letter saying it should be disregarded, but she refused to disregard the nonsense. You gave her the perfect excuse to disappear with the neighborhood plumber claiming that I had died in combat.
In fact, Doc Danica, isn't it true that Colonel Korn sent word that if you ever showed up at squadron headquarters, you would actually be cremated on the spot?
I was told that, but I'm not dead. Why is this so hard for you to understand? I thought lawyers were supposed to be smart people, but then again, I'm not surprised that the lawyer would ask me such a question. It reminds me of the joke about lawyers being the only people who could write a document of 10,000 words or more and call it a brief, except that it is not a joke.
Witness, let's not make lawyer jokes, please. I rarely find them funny.
I don't blame you, Judge. Shakespeare jokes were not kind to your profession.
I hate those in particular.
Okay, witness. There was no cremation of you as Colonel Korn directed, meaning that you did not show up, meaning that you did die in the plane crash.
Counsel, I think we have had enough of a line of questions that would make the witness think so little of our noble profession, don't you think?
Your Honor, perhaps I can explain.
All right.
There had been a mix-up. I had put down my name on the flight manifesto for the bombing raid, but I changed my mind at the last minute and did not go on the raid after all. So when the plane was shot down, everybody insisted that I must have been killed.
Is it possible that there's more to this story than that you simply changed your mind at the last minute?
Entirely possible.
I have no further questions, Your Honor.
And thank you very much, witness Dr. Danica. You may step down from the witness stand. Thank you. We will now begin with the defense evidence presentation. The only witness for the defense is Captain Yossarian himself. May the accused please take the stand? Witness stand. Thank you. Counsel, please.
May it please the court, and thank you, Your Honour. Witness, your name is John Yossarian, and you were a bombardier with the 256th Squadron during the war, and you held the rank of captain, is that correct?
Yes.
And during the war, you led the bombing raid on an undefended village in Pianosa, reducing it to a rubble. And for that mission, you've now been charged with war crimes.
Yes.
And you're denying criminal responsibility on grounds of insanity, obedience to superior orders, and military necessity, as the case may be?
Indeed so.
Captain Yossarian, how many times were you hospitalised in the war?
Loads of times. Once I had a pain in my liver that fell just short of jaundice. Doctors didn't like it. Because if it was jaundice, then they could treat it. And if it wasn't jaundice, then they could discharge me. But it being just short of jaundice really confused them. A lot of times it was also just because of my temperature. I always have a temperature of 101 degrees, so I could go to the hospital with a fever whenever I wanted.
101 degrees Celsius or Fahrenheit?
Fahrenheit, Your Honor.
All right. My understanding is that all but one of the state parties to the Rome Statute use Celsius. So we will speak in Celsius. That would convert your 101 degrees, I think, to about 38 degrees Celsius. Let's stick with that. Please proceed.
As the court pleases. On another point, witness, did you ever receive a medal for heroism?
Yes, I did.
And when your commanding officer, General Dweedle, went to give you that medal, you were standing in formation at the time, lined up with the other soldiers.
Yes, I was.
I understand there was a bit of difficulty pinning that medal on your shirt.
Yes.
Why was that?
There were two reasons. The first was that I wanted nothing to do with that medal. I'm not a hero. But they insisted on pinning it on me. So I did what I could to resist without resisting.
And how did you manage that?
I went to the medal ceremony with no clothes on.
And why did you go to so much trouble to avoid being decorated?
Because I wanted nothing to do with medals from my enemies.
But it was your own commanding officer that was trying to pin the medal on you. How could he be your enemy?
He was an accomplice in a plot to have me killed.
How so?
Every time I went up on a bombing mission, the enemy did their best to shoot me down and kill me. So what does my commanding officer do? He sends me on more bombing raids to get me shot and killed by the enemy, exponentially increasing the odds that that would happen. Anyone trying to kill me is my enemy, just like anyone increasing the odds that that would happen is my enemy. It's like that old saying goes, with friends like these, who needs enemies?
And what was the second reason you had for not having your clothes on during the medal ceremony?
I tried to impress on Dr. Nika that I was insane, but he wasn't taking me seriously. I thought he would have to take me seriously if I showed in public with no clothes on. I remember reading somewhere, King George, the one that lost the American colonies.
He finally started getting taken seriously in his own madness when he started running around naked in Buckingham Palace. It's like that movie, The Madness of King George. Have you seen it?
I don't recall now.
You should see it. Great movie. It teaches us that even kings, queens, and presidents can go raving mad like everyone else. Actually, looking through history, it makes you wonder how many of them inflicted their own particular brand of insanity on their own people and humanity in general.
Mr. Yossarian, I have a question to you. You observe that kings, queens, and presidents are like everyone else, not immune to madness.
Yes.
So surely you cannot say the same same law of madness to apply to judges. What do you think?
It depends on how this goes.
What?
It depends on whether you convict me at the end of this trial.
But, Captain, your conviction is a decision for the jury, not the judges.
Oh. Well, in that case, judges are not exempt from the laws of madness. They're human beings like everyone else.
But my instructions to the jury can influence whether or not they convict you, you know.
Oh. Well, in that case, judges are exempt from the laws of madness. They're human beings with special biological immunities.
Well, that does sound like the most sensible thing I've heard of all evening.
Thank you, Your Honor.
Except the other day I was knocked off my bicycle by a speeding car. It was a very close call.
Well, that reminds me of an incident in Arusha, Tanzania, in 1997, concerning the famous Akayesu case. You may have heard it. A very important witness was supposed to appear on the Monday. You and General, I believe. But on the weekend before that, one of the judges in the case chose to go horseback riding. It was all so sporting, you know, until he fell off the horse and gave everyone a fright, you see.
Well, Your Honours, in our respectful opinion, that would be a good ground for appeal. But we would like to know, what part of the anatomy did His Honour fall on?
I think we can move on.
Well, now that brings me to my next subject. Mr. Yossarian, as you know, an issue in this case is whether you were afflicted with insanity. Dr. Danica did not think you were. I must ask you then the question, what are your views on the matter?
If the question is whether or not I was insane, my answer is a categorical yes. I'm definitely crazy. I tried to convince Dr. Danica to say so I could get discharged, but he refused.
Even after you showed up without clothes at the medal ceremony?
Not even after that.
But, Mr. Yossarian, you were the one who signed up for the military. What did you think it was all about that you were getting yourself into, if you would then spend so much time trying to get out of it?
When I was a boy, I was taken by the smart uniforms of the soldiers, the recruiting advertisements that you could travel around the world, their love stories from all those places. But no one said that I had to kill other people or destroy their homes or villages, or the whole part about other people trying to kill you before you killed them. I mean, that was the bit that I found most terrifying, and that's why I wanted out. I particularly hate Colonel Cathcart in all this. He was the one that kept increasing the missions. See, I'd done enough missions to go home, but he just kept increasing them. I'd do the 40 I needed to go home, and then he'd make it 45. So I would do 45, and then they'd make it 50. Wouldn't that make you crazy?
Was it Colonel Cathcart or General Dreidel that was increasing the missions?
It doesn't make any difference to me. I hate them both.
At some point, you actually exceeded the number of missions required by Air Force headquarters. Isn't that right?
Yes, but they just kept going up. 50, 55, 60. They didn't care what headquarters said. They just kept increasing them.
But if you met the number required from headquarters, why couldn't you just go home?
Because they also said that I had to follow every order of my commanding officers. So even if Cathcart and Drita were disobeying Air Force headquarters by making me fly more missions than I was supposed to, I still had to fly them or I'd be guilty of insubordination. And the penalty for that during war can be death by firing squad.
Now, you have prompted my next question, but I'll ask it anyway, just so we're sure that we've covered that element of the case. How come you led the flying mission to bomb the undefended village, knowing it was undefended?
Yeah, we knew it was undefended, but we'd gotten orders to bomb it. And some soldiers were grumbling, but I did not crumble because I didn't want to get shot for insubordination by Colonel Cathcart on orders of General Dreidel.
Was there any other reason you were afraid that General Dreidel might have wanted to shoot you?
Yes. There was this personal issue with General Dreidel and me, and he was looking for the easiest excuse to have me up for insubordination and shot.
Did they explain their reasons for ordering the bombing mission?
Yes. It was on orders from above. They said they were going to create a roadblock to impede the enemy from advancing towards our base.
With that, Your Honours, I have no further questions for the witness.
Thank you very much, Counsel. We will now turn to the questioning from legal representative for victim. Victims Counsel.
Mr. President, thank you very much for the opportunity. Mr. Isorian, sir, are you aware of the harm you caused to the village when your bombs fell?
Look, I gotta be honest with you. It reached a point where I just didn't give a damn where they fell. I just didn't want to get killed. Killed by the enemy, killed by my commanding officer for sending me up to get killed by the enemy, or killed by my superior officers for disobeying orders to go on a bombing mission to get killed by the enemy. It was about survival.
Sir, so you have no awareness? In fact, you have no comment on the harm suffered by any of the victims in this case?
None, sorry.
Mr. President, it appears that in this trial, no one seems to be in a position to comment on the harm suffered by the victims. Your Honor, at this juncture, I would respectfully request the chamber to allow me to call evidence, particularly on the harm suffered by the victims, Your Honor.
Thank you very much, Counsel. Ordinarily, that would be a perfectly legitimate request to make, and as you know, we are always anxious to do the wishes of the victims. But in this case, there is no denying that the event did happen, nor that victims suffered harm. It seems to us that it's a matter now of liability, legal arguments about the responsibility, criminal responsibility of the accused. So why don't we not call further evidence to show suffering in this case?
Fair enough, Your Honor.
Thank you. Thank you. Is there any cross-examination?
Yes, indeed, Mr. President.
Thank you.
Captain Yossarian, I would first like to ask you some questions about your times in the hospital. You were saying you've been there many times, but you like being in the hospital, don't you?
Absolutely, I do. You don't have to fly combat missions when you're in the hospital. And when something goes wrong, you can get help. And you can scream. If you scream in the hospital, people come running over to help you. If you scream on the outside, they throw you in prison. Hey, look, I'll show you.
Wait, that's good. No. I think we quite get the point. Thank you.
Mr. President, perhaps I should pursue this matter of the dead man in his tent.
I think that may not help us much in getting to the legal liability in this case. Can we move on to some other thing?
Yes, Mr. President. Let's get down to brass tacks. Captain Yossarian, you said you were following orders when you bombed the village?
Indeed so.
But you went along with the order willingly. You did not resist or protest the order, did you?
I wasn't given any choice in the matter. At one point, I suggested that we drop flyers over the village so that people could evacuate before the bombing, but I was overruled by Lieutenant Colonel Korn.
Well, that was a very feeble effort on your part, wasn't it? Do you recall Lieutenant Dunbar?
Yes, he was one of my subordinates.
Lieutenant Dunbar had very vocally registered the strongest objection when Lieutenant Colonel Korn was handing down the order to bomb the village. Unlike him, you did not protest. To the contrary, you intervened and rebuked Dunbar for registering the objection. That's right, isn't it?
Lieutenant Dunbar was in a very different position to me. He could afford to register strong vocal objections against the commanding officer's orders. I did not have that luxury.
And yet he was junior to you, was he not?
Yeah, but he wasn't the one with the personal issue with the commanding officer. I was. And my sticking my neck out would have given my commanding officer the perfect excuse to have me up for insubordination and shot. That was the difference between Lieutenant Dunbar and myself.
Perhaps, Counsel, that would serve as a textbook example of one question too many. Do you still want to keep cross-examining this witness? Perhaps ask him the very details of the personal problem that he had with the commanding officer that nobody wants to tell us about?
I think I should leave it there for now. Thank you, Mr. President.
It sounds like a very wise decision indeed, Counsel. Now, witness, you have finished your testimony. We thank you very much for coming to assist us. Thank you. We will now hear closing statements from counsel in the case. After that, I shall give some very brief instructions to the jury. But now the closing statements, beginning with the prosecution.
Thank you, Your Honour. Well, I think that the prosecution's case is very clear in the end. Mr. Yossarian bombed this village. There is no dispute about that. Nor are there any grounds at all for excluding his criminal responsibility under Articles 31 and 33 of the Rome Statute. First, Captain Yossarian has no defence of having a mental disease or a mental defect. Dr. Danica was quite clear on that ground. He was quite clear that Mr. Yossarian would have been grounded had he been crazy. He wasn't grounded, so therefore he wasn't crazy. Further, the accused's testimony that we have just heard before this chamber makes it quite clear that he is lucid and of sound mind. Second, a duress defence is not available on these facts. There is nothing except speculation to suggest that Mr. Yossarian was actually at risk of death or serious bodily harm for not obeying orders to bomb the village. His fear that his commanding officer would have him shot for insubordination is neither here nor there. He testified to a personal issue being a reason for that fear, but he didn't tell us the details of that personal problem. I insist that such details are irrelevant. They do not matter. He simply had no legally excusable reason to bomb an undefended village. Indeed, it was callous of him to also use his personal issue with this commanding officer as an excuse to refuse an unlawful order to reduce an undefended village to rubble. He could just have been court-martialed. He chose to save his own neck, carry out an unlawful bombing raid that exposed an innocent civilian population to very great danger. Further, he took no necessary or reasonable steps to avoid whatever threat was posed to him. He could have done any number of other things and to avoid bombing that village. For example, he could have missed the bombing targets on purpose, but he didn't. He went ahead and bombed the undefended village. And third, a superior orders defence is not available on the facts before us. An order to bomb an undefended village is manifestly unlawful. There is no reasonable way otherwise to construe it. And fourth, the defence of military necessity. I shall leave it to you and the bench to address the jury on that defence. Thank you, Your Honours.
Thank you very much, Professor. we will now take closing statements from the victims' counsel.
Mr. President, Your Honors, victims in this case should not be forgotten at all. Even though, Your Honor, this trial was limited in its scope because of the agreed facts. But I have to say, Your Honor, these facts were agreed only between the parties. We, the victims, didn't have any opportunity to comment or object to it. In any case, Your Honor, we fully concur with the prosecution that Mr. Yossarian must bear full and criminal responsibility for the harms he has caused. Victims in this case expect justice to be done, and also victims expect to receive fair and prompt reparation for the harms they have suffered. This concludes my respectful submission, Your Honor. Thank you.
Thank you, counsel. Of course, we do hear you. The victims will never be forgotten, as indicated to you earlier. The victims, the accused person did bomb the place and caused harm to victims. Now we'll hear from the defense counsel.
Thank you, Your Honours. Your Honours, this was a vile and muddy war. Mr. Yossarian could have lived without it, lived forever, perhaps. Only a fraction of his countrymen would give up their lives to win it, and it was not his ambition to be among them. To die or not to die, that was the question. History did not demand Yossarian's premature demise. Justice could be satisfied without it. Progress did not hinge on it. Victory did not depend on it. That men would die was a matter of necessity. Which men would die, though, was a matter of circumstance, and Yossarian was willing to be the victim of anything but circumstance. It must also be noted, Your Honours, that Captain Yossarian lived in circumstances which would make a man crazy, not just in a war, but a war in this particular unit with mission requirements increased the moment they were exceeded. Insanity was the only option. Your Honours, in our submission, Mr. Yossarian's motivations and circumstances must be fully taken into account when deciding on the question of his criminal responsibility. I think Your Honours have heard more than enough evidence to conclude that he suffers from a mental disease or defect, that he acted under duress, and that he would never have appeared before you today had it not been for the instructions of his superior officers. My client cannot be held responsible for the failings of others and his own mind. We are sorry to the victims for the harm that they've suffered, but nevertheless, we submit that the only just result is an acquittal on all charges. Thank you very much, Your Honours.
Thank you very much. Thank you, everyone. I will now give my brief direction to the jury on the law, on what they must do.
Your Honour, excuse me. I'm sorry, the jury?
Yes, the jury.
But, Your Honour, excuse me again, but the Rome Statute doesn't allow for trials to be decided by jury. Article 74 of the statute says that it is for the trial chamber to decide the case.
You are perfectly right in that observation, counsel, but tonight I believe we can indulge our generous spirit and share the judicial duty with the jury. Who knows what might come of generosity here and there. Maybe they will return it someday. During budget times, you see.
Of course. Thank you, Your Honour.
Thank you. Now, ladies and gentlemen of the jury, we have now arrived to the point where you will do your bit so you can earn your dinner. It is late. you will now deliberate on the guilt or innocence of Mr. Yossarian based on the directions on the law that I will give you. We are confident that as ambassadors, you will publicly tell us whether or not he is guilty. As you have heard, the factual elements of all the crimes charged in this case are accepted as proven for purposes of this trial. The only matter for you now to consider is whether Mr. Yossarian is criminally responsible for the crimes as charged. The Rome Statute recognizes the defense of insanity, duress, and superior orders and sets out the standards for excluding criminal responsibility on those grounds. Regarding insanity, the required standard is that disease of the mind had deprived the accused of the capacity to appreciate the unlawfulness or the nature of his or her conduct, or the capacity to control his or her conduct in conformity to the law. Speaking of duress, the required standard is that the accused had acted under a threat of imminent death or of continuing or imminent serious bodily harm against himself or herself or another person, provided the accused acted necessarily and reasonably to avoid that threat and had harbored no intention to cause a greater harm than the one he or she sought to avoid. Such a threat may have come either from another person or from circumstances beyond the control of the accused. As for the defense of superior orders, the relevant provision of the Rome Statute is couched in the double negative, so I shall not trouble you with reading it out aloud. But it involves three conditions which must be satisfied. Generally speaking, those conditions have to do with questions of the autonomy of the accused to carry out the order he had received, as well as questions of the lawfulness of the order itself in the first place. In other words, whether or not he knew or ought to have known that the order was not lawful. Now, let us take a closer look at those conditions. The first condition concerns autonomy of the accused to carry out the order that he had received. And that condition is to the effect that the law that controlled the conduct of the accused at the material time did not allow him choice or discretion as to whether or not to obey the order he received. He must have been under an obligation to obey the order. The second condition of superior responsibility concerns the accused person's subjective appreciation of the unlawfulness of the order. This requires the court or the jury to be satisfied that the accused did not know that the order was unlawful. And as for the third condition, it concerns the accused person's objective appreciation of the unlawfulness of the order. That is to say, the court or the jury must be satisfied that the order was not manifestly unlawful on an apparent view. Members of the jury, you must answer these three questions in the affirmative before you can accept the defense of superior orders as exonerating him from individual criminal responsibility. Now, let us turn to the central question, whether the law that controlled Yossarian's conduct really did compel him to carry out the order to bomb the undefended village. You have had the evidence of his fears that he might have been shot by his superiors for insubordination had he disobeyed the order to bomb the village. Here, you're free to consider that the matter may be more complicated on the facts of this case than that. First, that fear, was it realistic or merely speculative? And here you're perfectly entitled to ask yourselves the question, were there intervening practical circumstances which might have allowed Yossarian, as the subordinate receiving the order, a measure of autonomy in the manner of execution of the order he had received from his superiors. You may recall in this connection that bit of evidence that on a previous occasion, Captain Yossarian had bungled a bombing mission by repeatedly missing his target. Still, he received a medal for that wholesome display of incompetence, which no doubt will warm the hearts of lovers of peace. It is up to you then to consider whether Yossarian would have been shot for insubordination had he gallantly and quietly dumped his bombs safely into the nearby sea, rather than reduce an undefended village to rubble? Or was it more likely that he might have received yet another medal for bravery and gallantry? You may pause here to consider, though we are under the pressure of time, that in the absence of strategic arms reduction treaty, which is known as START, S-T-A-R-T, that is effective, you would think that soldiers who pursue their own manner of START, as in strategic arms reduction techniques, by safely dumping their ordnance into the sea, provided they kill no whales, may receive the Nobel Prize for Peace, or at least be prime candidate for it, just as well as some powerful presidents who didn't ask for the thing in the first place. Now, returning and continuing in relation to the witness's ability or wiliness as a soldier, I cannot help but recall the observations of the German General Kurt von Hammerstein-Eckert. I'm told he was a good man, for he was known to have famously opposed Hitler and the Nazis. He said this about soldiers, and you may find it useful. I quote, "I divide my soldiers into 4 groups. There are clever, diligent, stupid, and lazy officers. Usually 2 characteristics are combined. Some are clever and diligent. The place is the general staff. The next lot are stupid and lazy. They make up 90% of every army and are suited to routine duties. Anyone who is both clever and lazy is qualified for the highest leadership duties because he possesses the intellectual clarity and composure necessary for difficult decisions. But one must beware of anyone who is stupid and diligent. He must not be entrusted with any responsibility because all he can cause is mischief," unquote. Now, a shorter message to the same effect comes in the manner of the famous aphorism often associated with Alexandre Dumas fils, which holds that, quote, "It is not necessary to attribute to malice that which is adequately explained by incompetence," unquote. One must suppose, of course, that military commanders in the guise of Mr. Yossarian's commanders might actually heed that creed. These are some, but not all, of the considerations that may assist you in answering the question of superior orders that arises in this case. But before I leave you to your deliberation, I must say a word or two very briefly, on the subject of military necessity. My observations in that regard are provoked by the evidence concerning the reasons that the undefended village became the subject of the bombing that reduced it to rubble. It was said, as you will no doubt recall, that the purpose was that the rubble thus created would impede the movement of the enemy land forces towards the military base of the armed forces to which Yossarian and his commanders belonged. To that extent, one may think that the bombing served a military objective. But the defense of military objective is highly improbable defense on the facts of this case. This is because the law recognizes only defense of military necessity. It is not enough to consider that the attack may serve a military objective. Here we may heed the wise words of Judge Pokar, formerly of the Appeals Chamber of International Criminal Tribunal for the former Yugoslavia, who observed as follows, quote, "Military necessity is distinct from and more stringent than that of military objective," unquote. I must stress that the necessity that affords a defense in international criminal law is not the necessity of the conduct in question to assist successful military operation. It is rather the legal necessity of the conduct in the sense that what the law allows as an exception to the general prohibition of violence against somebody else. Here, the controlling consideration at all times remains respect for the rule of law, even in the context of war. It is not, as some may think, a question of striking a balance between what war requires and what law commands. It is always about what the law commands and what it allows by way of exception to that which it commands. Such an acceptation of the rule of law over war is all too clear in the definition of military necessity offered in Article 14 of the Liber Code. It is a famous text on the subject, and it says this, quote, "Military necessity, as understood by modern civilized nations, consists in the necessity of those measures which are indispensable for securing the ends of the war, and which are, mark this, lawful according to the modern law and usages of war," unquote. All that is to say this, viewed in the light of either modern international criminal law or of general principles of law recognized by modern states, the correct legal paradigm that explains military necessity compels a pride of place for the general prohibition of intentional violence, yet within that legal framework, there is the exceptional recognition of the defense of necessity, usually understood as justification for even illegal acts of violence on grounds that the pressure of the prevailing circumstances or emergency not created or contributed to by the defendant compelled him to commit the illegal act. To understand how all of this works, we may consider the precedent offered by a case famously known in international law as the Caroline affair. Now, members of the jury, I must direct you to look past the titillating title. Caroline was a boat. But yes, the events did involve excitements of a different kind. The breakdown of diplomatic relations between the US and the UK beginning in 1837. The facts of the Caroline affair arose out of a brief spell of rebellion in Canada against British rule. The episode is known in Canadian constitutional history as the Upper Canada Rebellion. Now, who would think that Canadians would get up to such things as rebellions? But there you have it. William Lloyd Mackenzie, a feisty former mayor of Toronto, he was the one who led the rebellion. He briefly set up a rebel enclave on Navy Island on the Niagara River, where he and his 200 or so rebels declared a Republic of Canada with him as president. They used the American supply steamer called the Caroline to supply their enclave. In December 1838, the Royal Navy captured the Caroline. They set it ablaze and adrift towards the Niagara Falls. All the commotion resulted in the death of at least one American on board. In reprisal, the American soldiers set ablaze a British steamer that they had found in U.S. waters. All that occasioned the diplomatic standoff that we now know as the Caroline Affair. In the dispute, the British government contended that the destruction of the Caroline was compelled by military necessity. The Americans disagreed. When the dust of all that settled, it settled also the principle of law that concerns what should constitute the defense of necessity in international law. The resulting principle holds that for the defense of necessity to succeed, the circumstances must, quote, reveal a necessity of self-defense instant, overwhelming, leaving no choice of means and no moment for deliberation, unquote. And additionally, the action taken must, quote, involve nothing excessive, since the act justified by the necessity of the self-defense must be limited by the necessity and kept clearly within it, unquote. Now, applying that principle to the facts of our case, the conclusion becomes inescapable that reducing the undefended village to rubble reveals, on the available evidence, no pressure of circumstances or emergency that was, quote, instant, overwhelming, leaving no choice of means and no moment for deliberation, unquote. And I direct you to take that view. But it may well be more convenient for you to disregard all of that and take the view, the more practical view, that the defense didn't quite press the defense of necessity beyond merely alluding to it in their case. Now, members of the jury, it is your turn to deliberate and judge. You can deliberate as long as you want, as long as you do that in less than 1 minute. You will, of course, in doing so, do well to keep in mind the advice of a certain Thomas Middleman to juries. He said this, quote, wilt make haste to give up thy verdict, because thou wilt not give up thy dinner, unquote, and good luck. So this is where you deliberate and tell us your verdict.
They're all the jury.
Just wondering, just to save time. Stay in court and stay road for the bits. Yeah, sure. Doesn't see it. Should I get time? I think so. Bill? Stay road.
Chris?
Just go straight on.
Yeah, can just go straight to the podium.
And how long do you want? How long?
Oh? You want to bet?
No.
The reasonable jurors. Everything we've got.
Straight up. So it's lucky I brought it in with me. Who knows?
They never got shot.
You're allowed.
That's a good way.
Needs both.
Yeah.
Was it anonymity?
Victims get shot. The victims never get.
The victims never got any mention.
Exactly.
They kept trying.
That's a win. That's a win.
You were included.
Yes, that's
Storm fence?
even if you were just told no. Who are the jury? Which ones?
He was 20 during the hearing. But they've had their minute.
At dinner.
The lecturers.
I think
I think it was pretty smooth, no?
Here he comes. When
Same time.
had no idea. No idea.
Okay, I think we no, we can say it from we do have a verdict. Do we, Madam Forewoman? Please, what is your verdict?
Yes, the jury is in the position to declare that the accused is not guilty.
Accused is not
guilty.
Thank you very much. And the jury is discharged. Now, ladies and gentlemen, we had announced earlier the intention would have been for us to rise briefly so that we can hear reflections from Professor Jenkins and Professor Shebas on the Rome Statute 20th anniversary. But I think we should stay here in the interest of time and invite them to share those reflections with us. Professor Jenkins.
Thank you very much, Your Honour. And first, as prosecution counsel, I'd like to say I think that's an outrageous verdict. And of course, we will look at the rules about, surely you can appeal from a jury verdict that isn't supposed to be a jury in the court anyway. So we'll just lodge that we don't agree with it. Thank you very much for giving me the opportunity to offer some reflections on this important anniversary of the adoption of the Rome Statute. And my reflections are going to focus on what has been called the normative evolution of gender crimes. The first gender advisor, Professor Catherine McKinnon, first called certain crimes of gender and sexual violence gender crimes. And so I'll talk about that evolution and some reflections about the lack of progress in securing prosecution for those crimes, and therefore raising the challenge of achieving gender justice and whether that can ever be successful under international criminal law. So, trying to keep this fairly brief in the interests of time, the Rome Statute was unarguably an important moment in the evolution of gender crimes. It came in 1998 after significant progress throughout the 1990s in making inroads into the long silence about crimes of sexual violence committed primarily, but certainly not exclusively, against women and girls, and that these had become known as the sort of forgotten crimes of armed conflict. They were largely invisible, largely committed with impunity. But throughout the 1990s, as I say, there was very much a change leading up to the adoption of the Rome Statute. A number of reasons for this change. I think factually, there was a growing awareness of the pervasiveness of such crimes and armed conflict. We had in the 1990s the breaking of the silence of the so-called comfort women from World War II, and the historical research and the public voices of the comfort women came at exactly the same moment as awareness was growing of the same types of crimes being committed in the wars in the former Yugoslavia. These were becoming publicized and held in many ways a chilling reminder of what had happened to the women under the Japanese military in World War II. There was also a growing realization how sexual and gender violence was integral to the genocide in Rwanda and in other conflicts of the decade. I think there was also recognition that such crimes destroyed families and communities and were a major factor in the growing mass displacement of all peoples. That was factually. Normatively, there had also been developments throughout the 1990s. In particular, the Committee on Elimination of Discrimination Against Women had recognized gender-based violence against women as a form of discrimination, and the General Assembly had repeated that. So against this backdrop of factual and normative awareness of such crimes of gender and sexual-based violence, and then building on the prosecution policies and the emergent jurisprudence of the ad hoc criminal tribunals, it was asserted and campaigned for by women activists, particularly from the Women's Caucus for Gender Justice, that through the PrepComs and at the Rome negotiations, such crimes should be included in the jurisdiction of the court. And they were highly successful. The Rome Statute spells out for the first time in an international criminal statute that crimes of rape, sexual slavery, enforced prostitution, forced pregnancy, enforced sterilization, or any other form of sexual violence of comparable gravity are crimes against humanity, are contrary to the laws and customs applicable in international armed conflict and in non-international armed conflict. And importantly, and with great innovation, persecution as a crime against humanity is extended to encompass persecution on the basis of gender, encapsulating the concept of a crime against a group of persons as a collectivity based on their gender. And we celebrated. The statute was widely and rightly celebrated by women activists as giving the new court explicit new rules capable of challenging the historical exclusion of gender crimes from international humanitarian law and providing a detailed mandate that aspired to end impunity for gender crimes. Further, and given that gender-based violence was also recognized as being a violation of human rights law, as well as of international humanitarian law and international criminal law, the requirement in Article 21.3 that the application and interpretation of law pursuant to this article must also be consistent with internationally recognized human rights. And this becomes especially pertinent when it's read with the next phrase, that application of the criminal law must be without any adverse distinction founded on a number of grounds, including that of gender. And so Judge Odio Benito, in an early case, was able to assert that excluding sexual violence from consideration was discriminatory when there was a clear differential impact between girls and boys who had been recruited as child soldiers. But the statute goes beyond inclusion of gender crimes. It also recognises the importance of gender diversity in the composition of the court through the requirements for a fair representation of male and female judges, and taking into account the need to include judges with legal expertise on violence against women and children. The former, gender diversity, is a welcome departure from the male domination of other international courts and tribunals, and the latter acknowledges that expertise in criminal law or international law, or even being a woman, doesn't necessarily automatically assume understanding of gender-based violence and how gender permeates conflict and its aftermath. But of course, there were also compromises made in the Rome Statute. The most evident compromise was in the highly contested definition of gender. It creates a binary stance between the two sexes, male and female, a limited and limiting definition of gender. Although the final clause locates gender in the context of society, introduces what has been called a constructive ambiguity, which does allow for a more progressive reading of the statute where there is the will to do so. So, the Rome Statute was widely celebrated by feminists such as myself as being groundbreaking in terms of formal gender awareness and ensuring that crimes of sexual violence are legally recognised for what they are. They are not unfortunate consequences of conflict. They are not matters of private deviance, but rather, when committed on a widespread, systematic scale, they can be crimes against humanity, and when they are connected to war, they can be war crimes. They are commensurate with all other war crimes and crimes against humanity. But what since? That was 20 years ago. And I want just very briefly to raise 2 points. The first relates to the implementation of the provisions. The second is to flag the more problematic question of whether inclusion of gender crimes necessarily leads to a broader understanding and integration of gender justice. But gender justice is a broad term, capable of multiple meanings and nuances. I take as its goal that to transform the position of women and all other survivors of gender-based crime from that of victims to one of agents, for their voices to be heard, for their autonomy and individuality to be recognised and given effect, so that gender justice ceases to be something that women have to fight for and argue for, but is understood and recognised as integral to all systems of justice. To echo another commentator, the Rome Statute has built into its design formal rules with potentially transformative elements to bring about greater representation, recognition, and redistribution, with the capacity to reposition women and victims of gender-based violence as autonomous subjects of international criminal law to an extent that had never previously been possible. And I think it's this vision that makes it so important to continue to support the work of the International Criminal Court. But it also has to be admitted that to date the score sheet is disappointing, especially with respect to ending impunity and ensuring accountability, with a cascading effect of thereby limiting redistributive reparations. It began well. In the very first case, in the opening statement before the court, the then prosecutor, Luis Ocampo, turned to address what he termed, quote, the particular issue of sexual violence in the context of child recruitment and the fate of girl soldiers enlisted, conscripted, and used in combat by Lubanga's militias. As he explained, this was not just about what happened to girls, but it was more fully about the differential consequences for girls and boys. To quote him again, young boys were instructed to rape. Girl soldiers were the daily victims of rape by the commanders. Some girls were used as cooks and as fighters, as cleaners, as spies, as scouts, and as sexual slaves. They carried guns and served meals and were raped by their commanders. Boys were used to enforce this. But after this opening, which set out so clearly the importance of gender crimes, and despite relevant evidence, gender-based and sexual violence effectively disappeared from the case following the omission of charges at the relevant time. Only Judge Odio Benito, a judge who had a very long history of gender expertise, highlighted and made visible the gender dimensions of the crimes committed by and against child soldiers, using the opening provided for in Article 21.3 as a basis for her dissent on the basis of gender-based discrimination. In 2 subsequent cases where charges for relating to sexual violence were laid, the cases were dismissed as the accused were committed. So it wasn't until March 2016, in the Bemba case, that there was at last a conviction and a sentence of 18 years for such crimes on the basis of command responsibility, the form of liability that many feminists have long argued to be the most effective way of combating sexual violence and armed conflict, and the form of liability that's been urged by the Security Council in a series of resolutions. But, and as I'm sure you're all aware, the conviction was overturned by the appeal court in a split 3-2 decision last month. Now, there are many complex legal issues in that. I'm not going to go into the legal correctness of that overturning of the conviction. But the outcome, in the words of the Executive Director of the Women's Initiative for Gender Justice, creates, to quote, the stark reality that the court has not been able to deliver formal justice to victims of conflict-related sexual violence, and that thousands of victims who had hopes of justice and reparations stemming from Bemba's conviction have reasons to be greatly disappointed by this outcome, which seems to leave crimes that everyone knows occurred with no identifiable perpetrator, and to escape the assignment of responsibility that is supposed to be the essential function of international criminal justice, and further, in my terms, of gender justice. So the picture in response to prosecution of gender crimes is not to date great. But despite this, I remain optimistic that the court will be able and will deliver at least some of the aspirations of those committed to gender justice. A few reasons for this optimism. The recent surrender to the court of Al Hassan, accused of 6 charges of sexual and gender-based violence, rape, sexual slavery, forced marriage in Mali. The case against Dominic Ongwen, who has also been charged with forced marriage as a distinct crime from sexual slavery. Both these cases present new opportunities for exploration of these crimes, for their recognition as distinct crimes, and also of the particular social stigmatization faced by victims. A further cause for optimism is the high-profile commitment of now over 150 states to the prosecution of crimes of sexual violence, as illustrated by the 2014 commitment to end sexual violence and armed conflict. Of course, again, the Security Council mandate under its Women, Peace and Security resolutions, which constantly reiterates support for the Criminal Court, International Criminal Court, and the importance of such trials. And most importantly within the court is the pledge of the prosecutor to instill gender justice throughout the work of the OPT through the comprehensive gender policy adopted in 2014. And further, greater awareness and knowledge, understanding of how such cases should be prosecuted has been gained, for example, through the lessons learned from the prosecution in the ICTY, a recent book that has just come out, and from the collation of good practice in the International Protocol on the Documentation and Investigation of Sexual Violence and Conflict. All this, and the valuable input of the Gender Advisor, allows for the gender policy of 2014 to be a living and dynamic instrument in a court committed to the further evolution of gender crimes and to ensuring greater numbers of prosecutions and making impunity history. And I do not think we can overlook the important symbolic impact of the gender provisions within the Rome Statute. Yes, they will only be made effective through ongoing commitment and vigilance by those working within the court and champions outside the court. Engendering international criminal law and procedure has been described as slow, frustrating, and difficult. It's often marked by protracted struggles and compromise. We feminists perhaps excessively celebrate our small victories and laud our champions, and then return again to the struggle after setbacks. But, and I think this is what is most important to recognise on this 20th anniversary, when we look back at where we were in the 1990s, advances have been made which were then unthinkable, and these can still be furthered with greater support and generosity. Transforming international law with its gendered biases and blind spots was never going to be easy. It was never going to be quickly achieved. The heavy hand of patriarchy in international law is not so easily removed, but international criminal law has adapted more readily than other regimes of international law. Using international criminal law and institutions to advance for gender justice may be a blunt tool, but it's one that must not be abandoned, but must be furthered in practice and in advocacy, in holding states and international institutions to their commitments to end impunity, enhance accountability. And to this end, states must continue to support the International Criminal Court. Thank you.
Thank you very much, Professor Jenkins, for those reflections. I should have done this earlier. Perhaps some of you already know who she is. Professor Jenkins, for many years, was a full professor at the University of London, and now an emeritus professor with the great expert on the area of gender justice in international law and other aspects of international law. Thank you very much, Professor.
Thank you.
Now I turn to another professor, Professor Bill Shavers, who, again, some of you may already know. For many years, he was a professor at Galway University, and now he teaches at the University of Middlesex in London. Professor
And Leiden.
And Leiden. And Leiden. Professor Shavers, please.
Thank you.
Proceed.
Thank you very much, President, and thank you for organizing this fun afternoon of mock trial and for giving me the privilege of participating in it. Returning to an earlier career as a defense counsel many, many years ago in Canada, I'd forgotten how easy it is to get your client off, you know? But I think at the ICC, it's pretty straightforward, isn't it? It reminded me of a story about a jury trial where the defendant had a good argument, a good defense of insanity, and but the judge didn't think much of it. And as you pointed out, President, in one of your remarks earlier this afternoon, the judge in their charge to the jury can kind of influence the jury a little bit as to which way they go. Not that you did very much this afternoon. I could sense your remarks. But this judge was very convinced that the accused person was guilty. And the jury came back, just as they did this afternoon, and said, "Not guilty, my lord." And the judge was furious. And the judge turned to the jury foreman and said, "Not guilty? Well, what's the explanation?" And the jury foreman said, "Insanity, my lord." And the judge said, "All of you?" So, well, Yossarian's alleged crime of bombing the undefended village in Italy while acting under superior orders was a feature of practice during the Second World War. It was hardly the only incident of its kind. There are many examples, I think some here in the Netherlands, and certainly there were in northern France, where a number of cities in Normandy were virtually destroyed by Allied bombing as part of the liberation of France. City of, I think, Bayeux and Caen and Évreux, they were all reduced largely to rubble. And nobody was prosecuted for this. Nobody was held to account. We know that at the end of the Second World War, there was an absolutely marvelous trial in Nuremberg and another one in Tokyo, but these were of the losers. And there was no attempt to bring to trial the victors for crimes that they may have committed. And incidentally, these incidents I've referred to were far from the worst, because also there was terrible bombing, firebombing of cities in Germany. And of course, the war ended as well with the dropping of the atom bomb on the 2 Japanese cities. And so there was a dream after the war that we would have a permanent court. The Nuremberg Tribunal was not a permanent court. We would have a permanent court, and it would be empowered to judge everyone. That it would be a true court that could try the losers and the winners, the weak and the strong. But unlike other judicial institutions and other international organizations that arose in that dynamic period following the Second World War, the court was not to be. It took almost another 50 years. And that came to a close as the United Nations Security Council set up 2 tribunals, and they were an improvement in some respects over Nuremberg because of their independence and impartiality, but they still lacked that purity of an institution that could prosecute everybody. And for that, we had to wait for the International Criminal Court, and it was a marvelous achievement, and it filled a gap in this marvelous post-war, post-Second World War legal order that has guaranteed us now a period of relative peace for the last 73 years, and we hope for another 73, and yet one that seems to be slightly threatened. Now, some of you were at the Rome conference. I think we're a dwindling lot. My co-counsel Helen was here, and Judge Perrin de Brichambeau was there, and anyone else I've forgotten who was at the... We're a shrinking lot, which is an advantage because we can make up stories and no one can disagree with us, and deny the contrary. But we all remember the excitement of that conference, and also the stunning result, which was much more advanced than what would have been expected even 4 or 5 years ago. The proceedings began, the debate began, with a draft that came from the International Law Commission that basically envisaged a court that was a permanent version of the ad hoc tribunals, something that would be attached to the United Nations and that would be subject still to the power dynamics of the United Nations and in particular the Security Council. And things changed over the 5 years to give us a court that was much more detached from the political controls. James Crawford, Judge Crawford now, Professor Crawford at the time, who was the special rapporteur of the International Law Commission that produced the draft, often spoke about it, has often spoken about it, saying, we gave the world what we believed the world was ready for. It wasn't that we were conservative, we just realized that that court that you finally created in 1998 was maybe just a little too ambitious. But it certainly was ambitious. Was it too ambitious? Back in 1998, I was fond of quoting the French writer Victor Hugo, who said famously, "Nothing can stop an idea whose time has come." And I felt that was the case about the International Criminal Court. But maybe James Crawford, there was a grain of realism in his remark as well, that we were maybe a little early and that the world wasn't quite ready for the court. And I don't think we know the answer to that, but I think that it provides us with a means of understanding why it's been difficult at the International Criminal Court, why it's been more difficult than it seemed to be for the temporary, targeted ad hoc tribunals. I understand the frustration of people who work in the court, particularly the Office of the Prosecutor, distinguished lawyers like Helen Brady, who prospered at the court. They did their work, it worked, the court worked, and they find themselves at the International Criminal Court more frustrated because it doesn't seem to work as easily as it did. And the explanations for all of this are complex, but part of it is that we're dealing with a complex world and the environment makes it hard, harder maybe than it was in 1998, because that exciting decade that followed the end of the Cold War has been replaced now, 25 years later, by a world that's more frightening, by a world where we have nasty forces. We talk about the rise of populism even here in Europe, and its leaders play upon racism and xenophobia, hoping that that will propel them to power or keep them in power. And this means then that we have a court that's trying to exist in a more difficult environment. Now, people say sometimes history is going to repeat itself. We're going to find ourselves like in the 1930s. The big difference between where we are today and where we were in the 1930s is that we didn't have the International Criminal Court in the 1930s. We didn't have the United Nations in the 1930s. We didn't have the European Court of Human Rights in the 1930s. We didn't have the European Union. We didn't have the African Union. A huge number of institutions, courts, and a legal framework are now in place, and they're an obstacle to those who would like to revive some of those terrible forces that were finally temporarily successful in the 1930s. And that's why we have to fight so hard to protect the court, even if it goes through difficult times and frustrating times. It wasn't always easy for the International Court of Justice either, you know. They went through a long spell where they had very, very little work following an unfortunate decision about Southwest Africa in the middle 1960s that kind of undermined confidence of many countries in the independence and impartiality and, above all, the integrity of the court. And they were covered in the 1980s with the Nicaragua decision, and they've never been busier. I looked on the website recently. There are something like 18 cases proceeding at the International Court of Justice. They've never been so busy, and the time will come when we'll say the same about the International Criminal Court. One of the things that the enemies of this system know is that the courts have to be undermined, and we see that in many places. We see courts being undermined recently in Poland. In Britain, where I live, we had a terrible episode last year where a decision, not popular in certain quarters, it dealt with Brexit, a decision by the Supreme Court was greeted with absolutely scurrilous attacks on the court and on the judges for doing their job. We had an example of that this evening when Prosecutor Chinkin reacted with anger to the decision by the jury doing their job. And I dare say, and you know what I'm referring to now, the recent decision by the appeals chamber in the Bemba case provoked some of those reactions as well. Very unfortunate. As academics, we're used to criticizing judgments. That's part of our job. We write about them. We point out what we think are flaws or weaknesses in the judgment. But we have to do it in a spirit of respect and one that contributes to the independence and impartiality of the court, and not in a spirit that could undermine it, because we have to protect that. It's too important to us. Christine spoke a little bit about the judgment, and I want to just say a few words myself as well about it. Controversial, yes, obviously. I won't go into all of the issues, but one of the critiques of the judgment is that some of the judges of the appeals chamber, the majority, may have overstepped themselves by intruding on the, not showing proper deference to the judges of the trial chamber. You know, I read the Rome Statute, you can read it yourself. Article 81 says you have an appeal on the facts, period. It doesn't say anything about deference to the trial chamber. It says there's an appeal on the facts. Now, it's true at the Yugoslavia Tribunal that that appeal is somewhat narrower, but that's because the statute says it's narrower. It says that it's got to be an issue of an appeal on the facts that would result in a miscarriage of justice. And we don't have that in the Rome Statute. And the justification that was given even by the Yugoslavia Tribunal is that you need to show deference to the trial chamber because they hear the witnesses and they can assess their credibility. Well, that's a good reason. I'm not quarreling with that, except that the Bemba decision wasn't about the credibility of witnesses. What it was about reading the transcript. The judges read it. I don't know how many people are in the room who've read all of the paper in the Bemba decision. I guess 3 of them. They're all sitting here on the bench here with me. I doubt that anyone else has read all of that, all of the proceedings. But all I can say is that when 3 people read the proceedings of a trial, 3 experienced judges read it and say, you know, I'm not convinced. I have a reasonable doubt. I don't think the person's guilty. At least they haven't proven that he's guilty beyond a reasonable doubt, which is the standard. Well, we have to respect that. What else are they supposed to do? What is a court supposed to do? When 3 judges say, I've read everything, and I'm not convinced beyond a reasonable doubt that the person's guilty, they have to acquit. And who would want to have anything to do with a court that didn't act that way? Far from viewing this decision as something that is disappointing, it may be, you know, it's true that the court is there for justice for victims, but above all, it's there for justice to the accused. And that judgment should reassure us that this is a court that will respect the presumption of innocence, and it won't send someone to jail for various policy reasons because 3 judges read the proceedings and say, I don't see the evidence. I'm reassured by it. I'm actually far from being disappointed. My confidence in the court has increased greatly. I think that on the 20th anniversary of the Rome Statute, we should all be grateful that we have a court about which we can be so proud. Thank you.
to the conclusion. We tried to get in the mock trial to some of the lessons of the Rome Statute, some of the legal questions in it. But we did not want to do that through the boring format of straight-out lecture. We thought we should set up a fact scenario to discuss some of those subjects, and we were grateful to the authors of Joseph Heller, the author of Catch-22, Joseph Heller, for assisting with that novel. Thank you very much, everyone, for coming, and we'll see you tomorrow. Thank you.
Well, I'd love to.